So we are live now. I think we can start the session. Principal sir? Sir, can we start the session?
Yeah, please go ahead, ma'am.
Okay, sir. Thank you. Pooja ma'am, over to you.
Thank you so much, ma'am. A very good evening to one and all. I, Professor Pooja Bijagi, welcome you all to this panel discussion on relevance of mediation and conciliation and Indian legal perspective. I would like to welcome our panelists, Dr. Nachiket Mittal sir, Advocate Mahesh Vishwakarma sir, and Advocate Akash Raj sir. I will be hosting today's session along with Dr. Amrita Singh ma'am, who will be moderating today's event. Now, I would like to request our principal, sir, to kindly address our panelist guests and participants.
Thank you, Pooja. A very good evening to all. A very warm welcome to our guest speakers and panelists. Dr. Nachiketa Mittal, sir, who is a senior to me and from National Law School, alumnus of National Law School. And sir is also a director of Virtual Law School, founder and director of Virtual Law School. And we never thought that something this kind of would happen because of pandemic. He was optimistic and very positive, and now that Virtual Law School has become very famous, and so many teachers I could see on that WhatsApp group that so many teachers voluntarily are teaching, and it is very nice, sir. I congratulate you for the same. Having said that, I also thank sir for accepting our invitation. And on behalf of KLE Societies, KLE College of Law, I welcome you, sir. My dear friend, Advocate Vishwakarma, sir, practicing in Bombay High Court, and who is also a guest lecturer to our institute, keeps us giving new ideas. And he has also helped us for getting so many resource persons as well. Thank you, sir. Thank you for that. And the next panelist is Mr. Advocate Akash Raj from Patna High Court. Sir, thank you for joining us, and I welcome you on behalf of KLE Societies, KLE College of Law. I'm also obliged to the KLE management, especially Dr. Prabhakar Koreji, who is the chairman of KLE Society, Mr. Mahantesh Kavadgimat sir, governing body chairman, director of KLE Society, and MLC and Chief Whip, Karnataka government, Dr. Mallikarjunaya, principal of KLE College of Law, who is our mentor, for their continuous inspiration and guidance. Under your leadership, we surely will reach new levels in the academic field, sir. Having said that, without wasting much of our time, I would like to hand over this session to Dr. Amrita. Over to you, ma'am.
Thank you so much, Principal Sir. And once again, a very good evening to all the respected panelists for joining us for this very pertinent topic of mediation and conciliation. And before starting with the session, our first speaker, Dr. Nachiket Mittal Sir, before giving the session to you, sir, I would just like to take this opportunity to introduce your good self to our dear participants. Dr. Nachiket Mittal sir is a founder and director of Virtual Law School. Dr. Mittal sir was formerly Dean in charge of the United World School of Law, Karnavati University, Gandhinagar from May 2019 to April 2020. Dr. Mittal was also formerly a faculty of law in the National Law University, Odisha, Cuttack, India from 2011 to 2019. During his service at NLUO, Dr. Mittal was invited by the Honorable Chief Justice of India to the Supreme Court of India as Assistant Registrar Research on deputation to assist the Chief Justice of India in research and planning in the Supreme Court. He served on this position from February 2016 till October 2018. Sir has completed his PhD from NLUO in the field of access to justice for the rural poor, focusing on the operational issues and challenges concerning the implementation of the Gram Nyayalas Act 2008. Sir is regularly invited as a speaker in the international conferences and the law colleges in the United States. Sir has also worked with Arlington, USA, based on Ashoka's Law for All Initiative India chapter as a senior associate to provide technical legal support to the social entrepreneurs making legal intervention on public policy and social issues. Sir has also widely published on various subjects of law in the reputed international and national journals. Besides, Sir writes in the popular media like New Indian Express, The Statesman, The Deccan Herald, etc. on issues of public policy and socio-legal importance. So I think if I have missed anything, I will surely be apologetic for that. And with so much of knowledge and experience, I think, sir, our participants are going to benefit a lot from your lecture. Over to you, sir.
Thank you, Dr. Amrita, for a very detailed and generous introduction. It's always good to hear a lot of good things about oneself, you know. So, and a lot of programs offer that kind of opportunity to always hear somebody, you know, is speaking something good and, you know, praising you. So, but yeah, thank you so much for the generous introduction. And thank you, Professor Dinka. It's my pleasure to also electronically meet you. And I'm thankful to KLE Law College for inviting me on this very important subject matter and to share my views with all of you. And my greetings to my co-panelists here today, Advocate Mahesh and Advocate Akash. So you both, as I believe, would be adding the perspective as the legal practitioners on the issue of mediation and conciliation. So I would be dealing with the academic insights into it, and also having been the faculty of alternative dispute resolution and mediation and arbitration for last several years in NLU Odisha. So let's begin by looking at that kind of insight. So can Dr. Amrita, can I just get one input from your end that we have only our law students at KLE Law College attending, or do we have some other students from other law schools also attending the program?
We have participants from all over India.
Okay.
Yes, sir.
Wonderful. Okay. Yeah. So my dear friends, first of all, I must congratulate all of you to come and participate in this program today. Now, why do I say that? The reason is that when you have taken the admission in any law school in India, I'm trying to keep my focus more on the law students. So one thing is certain, that all of you are looking forward to be very effective and robust lawyers at the bar. And no doubt when we look at that kind of a paradigm of, you know, you coming out and enriching the bar, so definitely everyone tries to imitate and tries to look up to a lot of senior stalwarts in the legal profession and at the bar, right? So that you can be a very effective litigating counsel, and also some of you who may want to get into the corporate can be very promising in terms of the negotiation and a lot of contract drafting and mergers and acquisitions, so on and so forth. There's so much into even in the corporate field. Now, my reason to congratulate you was that in today's context, when we have over 35 million, 823,000 and around 722 cases pending in district courts and lower courts, it becomes very important to look at mediation and conciliation from a fresh eye, especially in today's context of COVID-19. So this is the data, my dear friends, that I could look up to, and you know, I could actually pull out this data from National Judicial Data Grid, which I would recommend all the law students and research scholars to time, you know, gather your data from there, which is updated by the courts in India. Then out of this 35 million cases, there are around 9,785,197 cases which are only civil. Now, this is the pendency that we have at the moment as I am speaking to you these days in the lower courts. No doubt there have been a lot of efforts made by the Supreme Court, High Courts, and respective district courts in different states across the India to arrest the ever-mounting growth of these civil cases which have been pending in the courts. But still, there's a long way to go. Now, COVID-19 has posed a fresh challenge. As you all can understand, the courts have gone virtual, which is a good thing. But there are certain limitations to it. Now, limitations are that you are going to be engaged into only the very urgent matters before the courts, be it criminal matters, civil matters. So the regularity of the cases which was heard in the physical courts before, we would say before March 2020, has now got disrupted. Now, what are the options available before us? When we talk about alternative dispute resolution, which has been for last several years been advocated and promoted by the central government, the state governments, and also by the Supreme Court and the High Courts, that appears to be one of the promising options that we should relook and revisit in today's context. Now, why I'm saying this as a law professor? The reason is that teaching ADR from a legal perspective in the law schools is one thing, but practicing and preparing you enough, so that you can marshal the art of mediation and conciliation is another thing. One of the very interesting and promising things which has taken place in last 5 or 6 months is that recently the Bar Council of India came up with its new circular that from the session of 2020 and 2021, the course on mediation should be made compulsory either as a component for the purpose of law teaching or compulsory paper or a subject. And this is to be embedded very clearly in the curriculum of law schools for the purpose of validating your degrees of law. Now, I would welcome this step, but at the same time, I would say that even before the Bar Council came up with the circular, we already had the compulsory course on alternative dispute resolution, which we usually call as ADR, that was taught in every law school in the country. So by default, the mediation was taught. But still, my experience so far has been that in the entire course of ADR, mediation sometimes takes a backseat. Most of the discussion, deliberation in the course, as well as part of the evaluation, is done on the arbitration law or to some extent the conciliation law. The reason is because conciliation and arbitration are codified laws, unlike mediation. And it becomes, I'm speaking it, as a professor, and some of my professor friends may disagree with me, but that's been my experience so far, that probably the reason is that it comes in handy, even in the legal academia, to teach ADR mainly central theme being based on the aspect of arbitration. So this has been, I personally believe, added reason why probably the BCI would have thought of carving out a special space for mediation as part of the LB curriculum, because something which was inherently there probably was getting missed out. So one, I would request all the law students to take that seriously, as well as my law teacher colleagues to pay now sufficient attention to that particular course. One. Second thing is, it is becoming increasingly important now in the COVID times and probably post-COVID also. The reason is that we came up with alternative dispute resolution, several years ago with regard to combating the docket explosion that the Indian courts are suffering. To tell you, friends, since the time is limited, we cannot quote a lot of data here, but it has not been the problem only in India. Even US, even UK, even Australia, South Africa, a lot of other countries in the West, they have been equally grappling with the issues of the cases being pending in the courts. And alternative dispute resolution, including mediation, conciliation, arbitration, have been the solutions all the jurisdictions, common law countries have been looking at very closely. So we are no exception to it. Rather, we are one of the very important parties to it. As a part of it, to tell you, some of you may not know, perhaps, I'm presuming that because I understand that law students may be from several different years and several different semesters in law schools, that in 2018, late in December of 2018, we also got something which is called a Singapore Mediation Convention. To tell you, before that, there was no internationally recognized kind of a soft law available on mediation specifically. So this has added a furthermore dimension and sort of an obligation on all the member states to now also promote mediation in a much more profound manner within their judicial structures. So that gives you one more kind of heads up to start practicing mediation. One. Now, what mediation and conciliation constitutes as per the discussion of the topic today, and why should you want to study it, and what is it that's going to open up perhaps certain avenues of jobs and career opportunities for all of you, something that I can talk about apart from the other legal aspects. So, my dear friends, especially the law friends, law student friends, please note that mediation in today's time is becoming important for the reasons that arbitration, which was expected originally to ease the docket of the courts, did not yield as much a result as was expected. Some of you who may not know, probably, let me mention out to you that in 1990s there was a amendment that was moved in the Code of Civil Procedure, Section 89, which is given the legislative color to the ADR by bringing within the fold of our civil procedure framework mediation, negotiation, conciliation, judicial settlement. And ever since that amendment, it has now become a permanent feature that as part of your civil disputes, if the parties want to mediate or arbitrate, then the courts allow the parties to first of all make that sort of an attempt to resolve the cases. And after that, if the cases are not resolved, they can definitely go ahead with the regular proceedings of the civil procedure. Now, this has yielded a good result to some extent, definitely. I would not deny that. Some of the high courts have taken a leap in terms of creating mediation centers, which are called as court annex mediation centers in the high courts. And the reason has been that when the court sends you for a mediation, so there is somebody, not the same judge who was hearing your civil dispute case or a case which was lined up in the court. It is somebody else who is deputed and nominated as a mediator. The reason is simple, because the same judge who may perhaps adjudicate the case as the judicial officer, if the same person is going to also act as a mediator, so his opinion will be clouded if, for example, your mediation doesn't come through. So there has to be that impartiality and neutrality that has to be maintained. At the same time, to tell all of my law student friends, please understand, in the mediation, element of confidentiality plays a very, very important role. One of the interesting features is that mediation is voluntary in process. So you can opt for private mediation, you can opt for court annex mediation also. Likewise, it goes for the arbitration. So arbitration clause now is invariably part and parcel of almost all the contracts that we sign, especially the commercial contracts that we sign. In some of the very intelligently drafted clauses or the dispute resolution clauses, you may often find, if you have been interning in the law firms or even in the companies with the in-house counsels, some of you might have, if had opportunity to look at the contracts drafting and the mediation clause, might have discovered that these days now there are not just the mediation or the arbitration clauses, but a very detailed dispute resolution clauses that first of all the parties would want to exhaust the options of negotiation, then mediation, then arbitration. And if nothing comes through, then obviously the courts of law are there for the purpose of looking at the cases. To remind you, we have one of the very classic incidents these days before us. If you all have been following closely the entire dispute that has been taking place in L&L Partners, which was earlier Luthra and Luthra Partners, right? So there's been dispute which has been going on between the managing partner, Mr. Rajiv Luthra, and one of the senior equity partners also. So if you have closely followed, the courts have ordered mediation, and again the parties are back to the courts. So it has not been a thing that only the normal litigants or the people in the commercial contracts have been experiencing the importance of mediation, but even the lawyers by themselves have been reposing great deal of faith in the mediation for the purpose of dispute resolution. The reasons can be attributed such as that it's inexpensive, it's very fast process, it's less procedural, and it's going to be amicable. Now, to tell you why the mediation and conciliation should be given more importance, especially during these times, I'm repeating that, my dear friends. The reason is that, मान लीजिए, some of you may think कि भाई arbitration is going to be far more value than the mediation, because you get a very binding judgment in arbitration and the parties will then have to follow. So there's one school of thought, even in the legal academia, even in the lawyers, who may think that नहीं, arbitration तो ज़्यादा बेहतर है, because conclusivity ज़्यादा है और binding nature ज़्यादा है, and you get almost the adjudication that you get from the courtroom, the similar kind of results you get from the arbitration. I would say to some extent it's right, but at the same time, the results in general show that arbitration is increasingly becoming as neo-litigation. Arbitration is no longer less expensive. In fact, arbitrations have become far more expensive in some cases than the regular cases themselves. One. Now, in the present day times of COVID, it has become complicated to complete the arbitration. I've been in touch with some of the judges of the High Court and Supreme Court who have been working as the mediators also and arbitrators also in different cases, at the same time with some of the leading lawyers. And my deliberations with them has revealed now that most of the people are looking at mediation as the next promising option. The reason is that in arbitration, you also need, like to some extent, like in the regular adjudication, about recording of the evidences. Now that is taking a back seat because the parties are not able to meet physically. Even although we may say that, the lockdown has watered down and now everything is opened up across the country and so on and so forth. So why are people not meeting? And if you see the Bihar election rallies, so nobody would be surprised and nobody can say that why shouldn't we meet as lawyers in a room where we may sit as maintaining a social distance. I completely agree with that. But still, the lawyers have been taking due precaution. Law firms have still not been opening their offices as frequently as they used to do it. So arbitration may evidence recording and lot of other depositions and witness testimonies are taking a backseat. Now, in this context, mediation comes handy. Why? Because it can also yield positive results through online medium, as we are now talking today at this very moment. Because at the end of the day, mediation is a very sophisticatedly improvised version of negotiation. Difference, my dear friends, for the law students to simplify and tell you is that negotiation is something that you and I do every day, right? You may be going out and making any purchase, physically you negotiate. You even negotiate with your siblings. So mediation is something where in negotiation, it is the two parties and their emotions actually overpower them. And then they are not able to resolve disputes. You require a third party to intervene in a very independent manner and help the parties to sever from their emotions and emotional baggages and bring the substance matter of dispute on the table. So to tell the law student friends, please always keep this kind of a element in mind. And also for some of you who are looking at the careers in law, the mediation skills are becoming increasingly important. The reasons, as I've been telling you, are that nobody wants to invest, as the companies, lakhs and millions of money and dollars, and even if it's in INR currency, the money to be logged in during the course of court proceedings, or even in the arbitration. So mediation serves that purpose of aligning the parties together. And one of the important attributes is that the harmony of the relationship between the parties does not get lost. Even in the arbitration, you will have one party winning. But in mediation, the idea is always that there should be some kind of a good takeaway by both the parties so that their relations stay well and they can still carry on the future business together. That's from the commercial side. At the same footing, we may we may try to look at that. Some of my lawyer friends may want to substantiate later here that mediation has also been very successful in disputes related to landlord and tenant, which has been escalating during COVID times. Some of you might have experienced. To tell you, I hope if my landlord is not hearing me, so I did had some kind of experience of that kind, but I could, overcome that kind of an experience. I didn't have to go to the mediator for that purpose. But even in that regard, I must tell you that mediation comes a very handy tool in these days, because during the lockdown phases of these kinds, you can't expect people to go and even before the courts for the mediation purposes in the court and next mediations. So the online methodology or the medium provides a very good avenue, right? One. Second thing, about the matrimonial disputes. Even matrimonial disputes can be very easily resolved by looking at mediation and trying to use those kinds of mechanisms where parties generally have very heavily loaded emotions, right? Because families are at stake, and given the Indian society, we have our, a lot of joint families also becoming part of the family disputes between husband and the wife, right? So in order to segregate those kinds of disputes, in order to make the husband and wife come on the table with the actual subject matter of dispute, mediators do a wonderful job. And that is the reason I tell you, when Professor Dinkar was introducing me, and even Dr. Pooja mentioned about the virtual law school that I am now running, taking a break from the active institutional law teaching, I have introduced mediation also as the course in the virtual law school, which was being taught by one of the very finest mediators, Advocate Reema Bhandari, at the virtual law school. So the reason has been that we, even as the academic side, value that mediation should definitely be one of the front running courses. And I'm sorry, my dear friends, even some of the friends from academia, Professor Dinkar and others, and lawyers and law students, to tell you, and anybody who may be listening to me as a law teacher, I'm sorry to say that mediation generally has become a side dish on the legal curriculum today. It is being generally given to anybody who could also be a research associate, that, oh, mediation में क्या है पढ़ाने का, ये तो कोई भी पढ़ा लेगा, किसी को भी दे दीजिए, right? हाँ, अगर सीपी से पढ़ाना है तो बात कीजिए, किसी लॉयर को बुलवाते हैं. Corporate law पढ़ाना है, then there has to be somebody, very well known, very experienced hand needed. But the courses like mediation are often, given a second seat, and that has been my area of little pain that I feel in the legal academia. But thankfully, till the time I was in active teaching, I could manage to retain my subject. And that's my earnest request to all the law students, that do not take it in a negative form, but take it positively, that when you have courses on mediation and conciliation being taught in your law schools, always demand for a very experienced faculty. And if not, at least demand for some of the guest lectures by the practitioners on mediation, so that you get hands-on experience. And the reason is because, unlike some other courses, mediation can best be learned only by simulation exercises, unless you try to do mediation in the classroom. Professor Dinkar too mentioned to you, when I used to teach mediation, so I always used to execute the simulation exercises between the law students. And this year, I was amazed that on 7th of July, I was teaching mediation, and I could recollect my slide of 5th July of 2015, when also I was teaching mediation, right? And so just to mention to you that it is very important that mediation course should be taken up seriously. And I would be happy to pitch in my support to the law school anytime, and also to discuss now and talk to you any further as a part of the question answers, if they are at all. I'm sure my co-panelists, who are the legal professionals, would definitely add more momentum to the entire deliberation by bringing in case studies, which definitely I wanted to refrain, because we all have our own jurisdictions and jobs to do, right? So I don't want to, step into the jurisdiction of my co-panelists here and do that job for them. So thank you, my dear friends. Please let me know if you have any questions after the co-panelists speak. Thank you.
Thank you so much, sir, for that wonderful lecture. And you have very nicely emphasized upon the the importance of teaching mediation and conciliation in the curriculums, focusing on the BCI's special, reference for mediation to be involved in the different law schools. And you had also talked about Singapore Mediation Convention, which is also a very, very important convention in recent times. Then you had also discussed very nicely about the career opportunities that are there in mediation, and specifically the importance of mediation during the COVID-19 times. To be more specific, like in the matters of landlord and tenants and the marital disputes. So thank you so much, sir, for the wonderful lecture. And now I would like to switch over to our next panelist, and that is Mr. Akash Raj. First of all, Akash, a very warm welcome to you. I remember you as my colleague in Amity Law School, Patna, and he was a wonderful teacher there. And apart from that, I would also like to take some time to introduce yourself also to the participants. Mr. Akash is a litigating advocate at Patna High Court. He has completed his law from Bharati Vidyapeeth University, Pune. Soon after his LLB, he started his practice at Patna High Court in the chamber of Advocate Bharat Lal. After a year, he started his independent practice. He has represented aggrieved students of Magad University, wherein the final year graduation result was withheld by the university due to non-affiliation of the colleges. The verdict of the case gave relief to 74,000 students whose career were on stake. Akash Raj specializes in criminal law, education law, family law, and service matters. He holds diploma in labor law, cyber law, and alternate dispute resolution. Akash is a gold medalist in the Master of Laws. A very warm welcome, Akash, and now the session is over to you.
Thank you, ma'am. Thank you, ma'am, for such a wonderful introduction that you have given about me. So without taking much of the time, I'll focus on the role of mediation and conciliation, especially in family disputes that we get to see every day in court. So starting with the word mediation, I mean, for a law student, it is very important to understand what is the meaning of mediation, what is conciliation, what is the historical background of mediation and conciliation, and how mediation and conciliation helps in solving the marital dispute between the families. So my presentation will be based on these. So first of all, mediation is a process of resolving dispute between parties outside the court of law. The concept of mediation and conciliation received legal recognition for the very first time through the Industrial Dispute Act 1947. The conciliators were appointed in accordance with Section 4 of this act, and they were given the duty to mediate and conciliate and promote the settlement of the industrial dispute through the process of mediation, so as to save the time of the court and that of the parties as well. It creates a win-win situation for both the parties to the dispute and also saves their money. The act also prescribes the detailed procedure for conciliation as well. The process of mediation and conciliation employs the same techniques and strategies in practice as well. The ideas of parties settling their dispute outside the court of law, that is the judiciary, was very known and prevalent in ancient India as well. Especially talking about arbitration, it was recognized as a dispute resolution process in 1879, and it was also included in the Civil Procedure Code 1908. The provisions of arbitration that was given under Section 89 of the Civil Procedure Code was repealed when the Arbitration Act came into force, and later court annexed ADR was reintroduced by way of amendment to CPC in 2002. Further, with the enactment of the Legal Service Authority Act 1987, there were certain duties which were vested with the National Legal Service Authority as a central authority with the Chief Justice of India as its chief. Basically, the duties of this authority was to encourage the settlement of dispute outside the court of law by way of negotiations, arbitration, and conciliation, to conduct research and surveys in the field of legal services relating to the resolution of dispute through mediation, to lay down policies and principles for making legal services available for everyone, to conduct legal training and educational programs in various law colleges and other institutions with affiliation to the Bar Council of India, in order to spread awareness about the process of mediation, so as to help them realize that going to the court is not the only solution in case of any disputes, and that there are alternatives for the same, such as arbitration and conciliation. To frame out most effective scheme for the purpose of spreading awareness about the concept of mediation. And later on, the Arbitration and Conciliation Act 1996 made much more elaborate and effective provisions for settlement of dispute arising out of a legal relationship, whether contractual or not, through arbitration and conciliation. The Act provided for the commencement of the conciliation proceedings, appointment of conciliators, and their duties, and assistance of suitable institution for the purpose of recommending and appointing conciliators. And most importantly, the conciliation settlement agreement was given the status equivalent to the degree of a court. The Act also specified the role of conciliator in assisting the parties to the dispute to arise at an amicable settlement. So basically, the concept of arbitration and conciliation was prevalent from ancient India as well. And since I am talking about the role of mediation and conciliation in relation to marital dispute, what we see every day in court, I'll be discussing and I'll be focusing more on that. Let's take an example. If a wife goes to the court and she files a complaint or FIR under section 498, 498A of the IPC, the first thing that the husband does, or for that matter, any family member who has been implicated, named in an FIR, they move for bail. And what is the approach of the sessions court while this bail application is moved? First of all, they send the matter to mediation center so that the husband and the wife can sit together, and a mediator is provided by the court itself. And if at that point of time, if the matter get resolved and the husband and the wife agrees on certain things which the mediator decides, but the mediator don't forces anything or don't impose his own judgment upon them, the role of the mediator becomes very effective at that point of time. The role of the mediator basically is, the mediator hears both the parties one by one. What I have experienced is that if I am representing the husband, so first of all, when the notice is issued to the husband appears before the mediator, and the concerning lawyer is with the husband. They both sit with the mediator. Mediator asks each and everything. Basically, mediator tries to find out what is the actual reason that there is this breakdown of marriage, and because of that, the legal action has been taken by the wife. So after listening everything about the husband, the problem, the mediator again calls the wife. Now wife with the concerning lawyer sit with the mediator. The mediator again tries to find out the actual problem, and if the problem, which is actually very much common in the husband as well as the wife, the mediator tries to settle those disputes. And once the dispute gets settled, the husband is provided the privilege of bail. Now, one question that is again becoming very important here is that in such matter, especially in Domestic Violence Act, whether mediation becomes an important role, or mediation works in the favor of the husband, that is many a time asked from us. So what we say is that the court is very much concerned about not breakdown of the marriage. The court is always trying, and court is there to protect the family, because the basic science behind marriage is to preserve the marriage, and court plays a very important role and tries to stop the parties into taking any action, or any to take any action, and so that mediator here becomes a very important, plays a very important role and helps the marriage from getting, breakdown. So coming into the next part, what is the role of the mediator and how the mediator should get into the, the facts of the case, or how the mediator should gain the confidence of the parties. That is very important, because one thing is about mediation is that it is very confidential. And when the mediator writes the report that whether the mediation has failed or the mediation is successful, he doesn't write about the entire case. He doesn't write about what the husband has said, what the wife has said. He merely writes that whether the mediation is successful or the mediation has failed. In this regard, Justice Manju Goyal, she has given certain strategies which a mediator should adopt while resolving family dispute. And she has stated that there should be probing of facts, there should be identifying the real cause of dispute, and exploration of possibilities of reconciliation or divorce. Bring the parties to an agreed solution and shaping the solution in the legal format. So this is what a mediator should keep into mind while mediating any family dispute. Now, there are certain advantages of this mediation in family dispute. So the legal aspect related to resolution of family dispute through mediation is, there is Section 5 of the Family Court Act of 1984, which provides a provision for the government to require the Association of Social Welfare Organization to hold the family court to arrive at a settlement. Section 6 of the Act provides for appointment of permanent counselors to effect and facilitate settlement in family matters. Moreover, Section 9 of the Family Courts Act 1984, Section 89 of CRPC, and Order 32A of the CPC, 89 of CPC and Order 32A of CPC 1908 make it obligatory on part of the court to give a fair chance to a negotiated settlement before adjudication is embarked upon. So basically, this is mandatory. Also, Section 23 of the Hindu Marriage Act 1955 concentrates on attempting reconciliation by the judge. So generally, when a civil suit is initiated, let's just say that a wife has filed a divorce petition or a husband has filed a divorce petition before the principal judge. So on the first date, basically the matter is admitted and notice is issued to the opposite party. And when the opposite party appears before the court, the matter is being, sent to mediation for the very first time, there only. Now this is pre-trial mediation. Trial has not commenced, and at this very early stage of the case, the court sent the matter to mediation. Now, if the mediator convince the husband and the wife, and the husband and wife agrees on what happens in mediation, then the case stops there only. But if the mediator is unable to resolve the dispute, the trial begins. And there are there is one more thing, that is there any chance of mediation once the trial starts? So there are opinions of different high courts and Supreme Court as well. Now coming to the next part, the role of the mediator. It is the role of the mediator to elicit the facts from the point of view of both the contending parties, and he would reformulate them in a clearer and expressed manner to let the parties focus on the actual troublesome areas of conflict rather than simply beating around the bush, thus giving an opportunity to the parties to come up with creative solutions which might not be possible in a third party imposed legal solution. The mediator can also talk to the contending parties individually without the other party being in discussion, so that the parties can clearly communicate to the mediator the areas of agreement and disagreement very clearly. As I have said this in the very beginning, that first of all, what the mediator does, he talks to one party personally, and thereafter he talks to other party personally. And thereafter he sets a meeting, and then the husband and the wife, along with their respective councils, they sit there, and the agreement or disagreement or the discussions that starts from there also. The mediator has to play the role of a counselor or a conciliator in order to lead the parties to an amicably acceptable solution to the disputes, which would bring about lasting peace between the disputants. The mediator has to advise the parties, and he may also have to act diplomatically to coax the parties to focus on the positives of a proposed solution. The solution to the dispute in question can be proposed by either of the two parties or by the mediator himself. The process of mediation might need more than one mediator at times to help the parties arrive at a mutually acceptable agreement. It depends upon the kind of disputes between the parties and also the emotional and mental situation of both both of them. Means the because in family dispute what happens, emotions is very much involved, so the mediator has to keep in mind that there should be check of the emotional balance as well. Now coming to the next part, there are certain judgments of different high courts and supreme courts that how they have encouraged the functioning of mediation and conciliation in family dispute. There is a case of Ram Gopal and another versus state of Madhya Pradesh, wherein there were certain non-compoundable offenses in IPC. For example, section 498A, that is a non-compoundable offense. But in this matter, it has been held that section 498A were to be made compoundable for easy settlement of parties between themselves, and which would also shred some burden from the shoulder of the judiciary. There is another case of B.S. Joshi and another versus state of Haryana and another. In this case, the court held that criminal proceedings. Hello? Am I
Yes,
audible?
Akash, I think, yes, you are audible, I think, but we cannot see your video. You're audible.
Okay. I'll continue, ma'am. I'll continue.
Yes, yes,
I
yes.
think video. In this case, it was held that criminal proceedings can be quashed at the discretion of the High Court by the use of power vested in the court according to section 482 of CRPC. It was an appeal petition to the Supreme Court. The wife had lodged an FIR against the husband, and later, according to her, their relationship was fine and the FIR was registered without thinking and impulsively. According to the Supreme Court, courts should encourage reconciliation, especially in the matters of matrimonial dispute of this kind. So basically, these judgments by Supreme Courts and other high courts, they basically focuses on, even if the matter is non-compoundable in nature, but when the life of the husband and the wife and the family dispute which is going on between the husband of the wife, that is at stake, then in that case also, the higher court, the Supreme Court and the high court can quash the criminal proceedings that is going on between the parties. I remember one incident while I was appearing for the husband. It was a case wherein FIR was lodged against the husband, and the alleged offense was section 498 of the 498A of the IPC. One of the honorable judge said that because generally the informant party was present, and informant party was very much aggressive, and he was praying from the court that he does not deserve the privilege of anticipatory bail, and his bail should he should not be granted the privilege of bail. Now honorable judge said that uh, this is a family dispute, and at the end, if everything gets resolved with time, and the husband goes to jail, goes to jail because of his rejection of anticipatory bail, and thereafter I don't think that there will be any chance that the marriage can be restored, because the husband will have a sense of dissatisfaction that he has been sent to jail because the advocate for the informant has opposed his bail application. So the Honorable Court in that case sent referred the matter to mediation. And ultimately, what happened in the mediation, the matter got resolved, and the husband was, given the privilege of anticipatory bail, and ultimately the marriage dispute got resolved there only. Because in the mediation, the mediator played a very important role. I was also present on behalf of the husband, and the advocate for the informant was also present there. And that FIR was lodged in a very impulsive manner by the wife, because nowadays, the institution of marriage has lost is its very much sanctity. So these are certain judgments of Supreme Courts and High Courts wherein they have encouraged it. So the ending my arguments and submissions and my presentation, I would say that in family dispute, the High Courts as well as the Supreme Court, they are encouraging, they are giving certain observations in different judgments, that mediation and conciliation as a tool should be used to settle the matter, especially in family dispute. So, ma'am, that is how I end my session, ma'am. If the participants have any question, they may ask at the end of the session.
Sure, Mr. Akash. Thank you for that wonderful lecture. You have focused on, you have explained nicely what mediation is, what is the role of mediator, and then how you have wonderfully explained the role of mediation in the marital dispute, especially telling about the different Supreme Court and High Court cases. Thank you, Mr. Akash, for that wonderful lecture. And I think you are. An inspiration of to a lot of young students out there, because you have you know helped them and worked for them so much. And I know your you that in Patna, what your fan following is. So wishing you all
Thank
the
you,
best.
ma'am.
Thank you for the wonderful lecture.
Thank you.
Now I just would like to move on to our next panelist, Mr. Mahesh Vishwakarma sir. First of all, Mahesh Vishwakarma sir is like a family to KLE College of Law, Navi Mumbai, because he is the one of our faculties in there, and he has contributed a lot in so many ways to the students, and of course, big fan following, sir, you have in our students also. So, a very warm welcome, sir, once again. And before giving the session to you, I would just like to introduce your good self also to the participants. Mr. Vishwakarma sir is one of the founding partners of Vishwakarma and Associates. After having completed his graduation in science from Mumbai University, he completed his bachelor's in law from Mumbai University and then pursued his master's in law in business laws from Bharati Vidyapeeth Deemed University, Pune. With his profound knowledge in the field of law and meaningful association with Messrs. PKD Associates in Delhi in the early years of his career, Mr. Vishwakarma sir is possessed of enviable tact, outstanding eloquence, and presentation skills. A very warm welcome, sir, once again. And now the session is over to you.
Thank you, Amrita ji, and thank you to CBC that he has given me an opportunity to speak here with so many good, eloquent speakers, Nachiket ji and Ashish ji. Indeed, Ashish ji has given a beautiful explanation of the court proceedings in the matters of matrimonial disputes, and Nachiket ji has given an insight of overall view of how this ADR kind of thing, जिसके बारे में बहुत सारा हम लोगों ने अपने कॉलेज टाइम में सुना था, कुछ अब होते हुए देख रहे हैं. So Mr. Nachiket has given a very systematic overview of that, and he has guided us to the current scenario of this mediation, conciliation, and arbitration. Now, if I am, I have to give something further to that. So there remains a very less scope of giving anything. However, I'll try my level best to give some more insights of what Mr. Nachiket and Mr. Ashish has left over, because as Mr. Nachiket has already stated, that he will not intervene into the area of what the other panelists are going to. So accordingly, there are some points that he has left for me, which I am going to elaborate before this in this session. So as Mr. Nachiket and Mr. Uh, Ashish Raj, they have said that this mediation and arbitration conciliation, this is a very lately, this has come to the legal fraternity, to the legal field. It has been recognized very lately by us, by our Indian people. But at the same time, Mr. Ashish Raj has pointed out that it was in the year 1947 that in the Industrial Disputes Act, Section 4, there somewhere conciliations were appointed and so and so. However, leaving apart from apart this present current modern law practice and the practice which has been developed after the Britishers, there was a practice, a good practice of Nyaya system, the judiciary in our India. It was basically called as panchayats. These panchayats, they were the basis of the Nyaya Vyavastha of our culture. And on the basis of this Nyaya Vyavastha, we had our panchas and panchayats. It goes to somewhere in Brahmakaranya, Brihad Aranyaka Upanishad. Brihad Aranyaka Upanishad, it goes there. There were Srinis, Kulas, and Pugas. They were all described, and all together they were called as panchas, and the panchayat used to run there. And for this purpose, to know this small definitions of how this was known, this mediation was known in the era that was pre-British era, that we'll have something, some presentation that if Dr. Amrita could please share us, we'll be,
Sure, sir.
be able to show that.
We'll do that. Do that, sir. Just
Apart from that, this is something. I'll say that my legal team, my legal research team from KLE, they have helped me a lot. The students, I am finding them as very proactive. I'll say they have helped me a lot in preparing this presentation. So therefore, my anxiety is there to present this, and I would need appreciation for my team from all the panelists as well as the participants. So this background, talking about the background, we had the first case in India. We had the first case in our epics that was in Mahabharata. We can go there. Kauravas and Pandavas, they were on the verge of fighting. They were on the verge of having their war started. And there, this Mr. Krishna Bhagwan, Lord Krishna, he takes the lead, and he goes to Kauravas and gives proposals, several alternatives. He has given several alternatives. Even he came down to the extent that give me 5 villages, give 5 villages to those Pandavas, and the dispute will be resolved and the bloodshed would be resolved. So this is what a proactive mediator does. He is not taking decisions. However, he is giving several alternatives for the others. Now, going ahead, as I said, there was the background was about panchas, that was Pugas and Srenis and Kulas. There we have this Pugas. It was again a board of persons who belonged to different sects and tribes but lived in the same locality. Srenis, the assembly of tradesmen and artisans belonging to different tribes but connected in some way or other with each other. Family, then Kulas were the family or the clan, that is kinships that was seen, that this Kul would be practicing this, forming a group of persons bound by family ties. So these all the constitutes of panchayats, and they used to guide us. And then if there is something that is not substantiated, it could be said to the king, and then the king would revise it. So that is how it used to work there also. But after the British era, it changed a lot. That we'll be seeing. definitions, going to the definitions, there are certain definitions that has been given by the eminent persons. In Albert Einstein's view, there is always an opportunity in the middle of everything. That is the golden view that I say. This is a golden view in respect of resolving any dispute. Then if we go legally, Black's Law Dictionary says a method of non-binding dispute resolution involving a neutral third party who tries to help the disputing parties to reach a mutually agreeable solution. Why this non-binding? As Mr. Ashish has said, that whatever is said and whatever is heard in the chamber of the mediator, that remains with him. Only a single line comes out of his chamber, that is whether the mediation is successful or it is not successful. So this. And then Abraham Lincoln, an eminent lawyer, he also says, discourage litigation. He says, discourage litigation, persuade your neighbors to compromise whenever you can. As a peacemaker, the lawyer has superior opportunity of being a good man. There will still be business enough. So both views are taken here. So if you are a lawyer and you are becoming a lawyer, don't think that if you resolve the disputes on your table by mitigating, by mingling with the parties, by giving them the suggestions, by mediation, then you will lose business. But think that there would be enough business for you. Do something in the line of advocacy which is expected from you. That is what he would say. And then is coming to provisions of mediations in India. As Mr. Ashish has said, starting from Industrial Dispute Act, I won't be going into the insight of it. I would be just pointing out how and which are the provisions. Then also, what is the status? There only I am trying to go. So quickly, Amrita Madam, you can pass over this because I need to go to the other slides. I'll be just naming them and accordingly you may move ahead. So here the provisions as have been discussed, Section 4 of Industrial Dispute Act, Section 89 of CPC, and Order 1, Rule 1A, Order 10, Rule 1A. This, I wish to speak about this. For my advocates, my friends, and my students and the other students, what I wish to say that litigation is something on every fora, on every platform. In litigation, there is an opportunity given to the litigants and the advocates to resolve their dispute by way of mediation. And that is what is about Order 10, Rule 1A of the Code of Civil Procedure. This, read with Section 89 of CPC, gives an opportunity to the litigants that at the stage of admission denial only, you can resolve your disputes. However, there are very less occasions that I could see in the courts that people are exercising this. We'll be coming to that. And then, as Mr. Ashish said, Order 32A for resolving the family disputes, and then Legal Services Authority Act 1987, and then Lok Adalats, they were all built. And then there are provisions of provisions under Section 442 of Companies Act also there, which is stating that you may appoint counselors and mediators to resolve the disputes. If the matter goes before the NCLT, then also you can go ahead for this, and NCLT will refer that matters. Then if you consider micro, small and medium enterprises, MSME Development Act, there also Section 18, it gives a way to your mediation. Then Section 14.2 of Hindu Marriage Act and Section 29.2 of Special Marriage Act again speaks of the same. Section 32G of Real Estate Regulations and Development Act 2016, that also is again giving a way for the litigants who are willing to resolve their disputes inter se between the allottees, the flat takers, the purchasers, and the developers. Then Section 12A of Commercial Courts Act, this 2015, this was started. This need was understood by the Parliament, and then this was enacted, and it was inserted in 2018 amendment in the Commercial Courts Act 2015. See how the Commercial Courts Act was made in 2015. However, it was inserted. This 12A was inserted in 2018. This says, this particular provision, I'm a big fan of this. However, nothing works here as well, but I'm a fan of this. It talks about pre-litigation, pre-institution of litigation mediation. The mediation at the stage of pre-institution. So if you have a grudge, if you have a dispute, you can go to the mediator, you can file your application claim there, you will be called for mediation, the other parties would be called, within 10 days, everything is done. And then if you are resolved, you resolve your dispute. If the advocates, I'll say, if they take part into this, if they take active part into this and they help their clients to resolve their disputes, yes, this is the stage where most of the disputes can be resolved. But unfortunately, there are certain, still I am seeing the exceptions, and so many of the cases could not be resolved, are still pending. Then there comes Section 37, 38 of Chapter 5 of Consumer Protection Act. There also, if with the help of the consent of the parties, within 5 days of the question posed to them, they can, the officer, the presiding officer may send the matter for mediation, and they may resolve there. And see how nice so you are litigating. And if you see that 2 years have elapsed, 4 years have elapsed, and you decide that on one fine day, you decide that you have to settle your matter then and there itself, you may approach the presiding officer with an application, and then it will be decided then and there itself. Though these provisions are there, these statutes, they give us. They tell us that within 1 year or 2 years, your disputes would be resolved, your matter would be resolved. But owing to the backlog that Mr. Nachiket has pointed out, 35 million overall and 9 million civil courts, the lower courts and other courts, dependency of the matters. Owing to this pendency, yes, वो ऐसा हो जाता है ना कि हाँ भाई मैं कर तो आज सकता ही हूँ एक मैटर, लेकिन इतना सारा पेंडिंग है, वो देख के जज डर जाता है बहुत बारी. So therefore he is not able to resolve it. So rather he is not able to adjudicate it. I'll say he is not able to adjudicate. Most of the times I have seen that the advocates, they themselves try to prolong the matters. There are a number of reasons. I don't wish to talk on that, but there is this status that the advocates are also an instrument in prolonging the disputes before the courts. So if the advocates decide to take this alternate dispute resolution mechanism, the mediation, as Mr. Nachiket has said, that the arbitration, earlier it was good, now it is not less expensive, but it is more expensive than the litigation. In some of the litigations I've seen, the advocates, they take fees of 10 lakh rupees per appearance. That is the status now. That is the situation now of the litigations, of the arbitrations. Though there is this Asia Pacific Center for Mediation and Conciliation that has been this inaugurated this very recently by Justice Nariman, where there are about 9 countries participant to that. Though this endeavor has been taken, but the fact remains, it is very expensive. Not expensive as you could have in New York or Singapore or other countries, but it is expensive. Still, it is expensive. So what is the best way to resolve it? Mediation. Mediation is the safest way. Even I'll tell you that there are instances and the stages, as per the stage of litigation, if you approach for mediation, your court fees is returned to you. Sometimes it is returned in 100% to you. So why not exercise this? One has to exercise this. Then comes the analysis on this part, this broad view. I'll say that whatever we have discussed, whatever we have seen, those are the provisions. Let us see what is the effect of those provisions in our country. It cannot be said that India does not have provisions regarding mediation or use of conciliation. Yes, I'm saying this as I've shown you that most of the areas of dispute, labor, yes, there is mediation; consumer, yes, there is dispute; matrimonial, yes, there is a dispute resolution through mediation; civil disputes, property disputes, yes, there is this mechanism. However, what is the status of cases? It is growing day by day. Let us think this way: when this court system, this judiciary, after Britishers, post-Britishers, when this started, it might be having one case or 10 or 100. What is the status now? Look at the figures: 35 million, 9 million. This is the status. If this is the status, what can we think of? We can definitely think and point out that yes, these numbers are not going to come down, rather these numbers are going to increase day by day. And that is what we have seen. That is what the past is. So the discrepancies between mediation and conciliation obstructs these provisions from being successful. This is what I have found till now. As Dr. Nachiket has rightly pointed out, कि जैसे ही mediation के बारे में बात होती है, लोग भाग जाते हैं. पढ़ना नहीं चाहता है कोई और कोई पढ़ाना नहीं चाहता है. पढ़ाने वाला जो होता है वो कोई भी चल जाएगा. एक एक्सपीरियंस आदमी नहीं होना चाहिए. Expensive affair नहीं होनी चाहिए. I say that this is the time in colleges when we have to insist upon that yes, this is the course which this is the part of the course that has to be given more emphasis. Then a uniform legislation concerning mediation between the various places of existing legislation is required. This is what we have found. Lack of procedure and guidance in this regard. A panel to have draft legislation to give a legal sanctity to disputes settled through mediation is set up by the Supreme Court. Yes, of course, now very recently I have seen that Mr. Siddharth Luthra, senior advocate, Supreme Court, and one more advocate, I don't remember, senior advocate, both of them have given some pointers for setting up, for making changes in your 138 Negotiable Instruments Act, the trial in those matters. There also the emphasis is more on mediation. And then, so Supreme Court and other courts, they are definitely working. They are working, and definitely we see that some good outcome would be coming out of it. As of now, yes, we do have laws, but they are to some extent not able to serve the purpose. Then thereafter, what is it? Madam, please take us to the next slide. The need of mediation. Why this need of mediation? My team has pointed out this, that the right to a speedy trial is a fundamental right, implicit the guarantee of life and personal liberty enshrined in Article 21 of the Indian Constitution. Yes, we understand this, we know this, but knowing this fact, we still are not able to serve our clients, serve the judiciary, serve the humanity by expediting the issues, by referring these matters to mediations or any alternate dispute resolution system. But where are we stuck? We are stuck for personal reasons, or might be some other reasons, that we are still going by the conventional method of litigation, and then we are delaying the matters. In developing countries like India, there is excessive overburdening of courts, as we have seen from the data that has been given by the other panelists. The large number of pending cases on the docket has ultimately led to dissatisfaction among the people regarding the judicial system and its ability to provide justice. Now, this is what I always used to say. बाहर किसी से अगर कोई लफड़ा हो जाता है तो लोग क्या बोलते हैं? I'll see you in court. हर कोई बोलता है I'll see you in court, लेकिन जब वो कोर्ट में जाता है तो उसका दम निकल जाता है. क्यों दम निकल जाता है? This is the fact, क्योंकि डिले इतना होता है कि उसकी इच्छा ही मर जाती है. Thus, the popular belief, the justice delayed is justice denied, is prevailing, which we need to remove. Next slide, ma'am, please. Ground reality, this has been talked earlier, so I'm not talking about this. Let us go ahead, madam. The primary reason for growing pendency of cases is that number of new cases filed every year has outpaced the number of disposed cases. This is the fact. Then one interesting factor to note is that more criminal cases are filed in subordinate courts than in the High Court and Supreme Court. Of the cases pending in subordinate courts, which constitute 87% of all the pending cases, 70% of the cases were related to criminal matters. This increase in the pendency of the cases for long periods over the years may have directly resulted in an increase in the number of the under trial in prisoners. This is what we feel. Then under trial constitute a significant majority of the prisoner population, that is 67.6% against the convicts ratio of 31.5%. See the difference. 67.6% are there, but out of them only conviction will be 31.5%. Now this, why it is, we tried to summarize this. There are approximately 59,867 criminal cases pending before the Supreme Court of India. The condition is even worse in subordinate judicial system. Like there are 44.75 lakh pending cases before the various high courts of India and 3.14 crore pending cases before the district and subordinate courts. Pendency of cases across courts in India has increased in last 1 decade. In various high courts, around 25% of the cases pending before it since 10 years. The pendency of the cases before the judiciary has become a challenge for the judicial system of our country. Please move on to next slide. So this is the data. Though I did not want to talk about this, it has come. So I'll talk about this as well. There are over 3 lakh persons who are within prisons as under trial and presumed to be innocent in the eyes of law. As I said, 67 and 31%. The purpose of keeping under trials in the custody is to ensure fair trial so that they cannot be in a position to influence or induce the witnesses. This is the whole purpose of keeping a person into custody. Long detention of under trial causes a number of problems to the other prisoners and to prison organizations as well. Nowadays that we have seen that due to pandemic, COVID-19 pandemic, we had to vacate our prisons. We had to vacate our prisons by passing an order, a general order that up to 7 years you will be given bail. Why not this was done earlier? Well, this could have been done earlier. Nevertheless, the majority of under trials are poor and denied bail due to excessive bail security, and thus trials take years usually. They have no lawyers, live in pathetic conditions, they do not have access to adequate medical care, and are likely to be tortured or exploited. This is the ground reality. This is what we see in day-to-day life. Please move on to next slide. To this, there has been a solution which the other countries have exercised, and we are also exercising. Till 2006, we were not a party to that. We were not believing in that. However, since 2016, 2006, we started this plea bargaining, and that is very much within our. It was there. I can't say that it was not there in our provision, but it is there. It was there. However, we were not exercising it. So, Section 265A to 265L in Chapter 21A of CRPC, this is provided. The plea bargaining has been provided. Unlike in the US and the other countries where the prosecutor plays a key role, there they have their prosecutor, he himself, proposes to the accused that देखो इतना कर लो, इतने में खत्म कर देते हैं, इतने साल के लिए अंदर हो जाओ, इतने में कर देते हैं, और conviction, they'll secure the conviction. यहाँ क्या होता है? यहाँ पे accused has to go there and propose that please मेरे को इसमें plea bargaining करनी है, आप सुन लो मेरी बात. See, क्यों होगा, कैसे होगा, ये वकील कब समझाएगा, वकील क्यों समझाएगा? There lies the problem. And because of this, the conviction rate, that is 31.7% against 61%. Then the accused, the limited, this is limited, this plea bargaining is limited only for someone who has been charged sheeted for an offense that does not attract the death penalty or life sentence or a prison term above the 7 years. can make use of the scheme under chapter 21A. The accused may be sentenced to prison term that is half the minimum period. Also, this is applicable to the offences. This is not applicable to the offences which is against the women and children. So that is also a part. Then accused may be sentenced to prison term that is half the minimum period fixed for the sentence. If there is no minimum term prescribed, the sentence should run up to 1/4 of the maximum sentence stipulated in law. It may also involve fine. So this is how the scheme is. I am still unaware why the people are not promoting this. Please turn on to next slide, ma'am. Why the people are still not working on this? The one reason that I can find out, as Dr. Nachiket had said, that yes, because this subject has not been taken seriously in the colleges. And rightly he has pointed out, to some extent, that can be eradicated through the colleges itself. Then see the latest instance of pre-bargaining. Tablighi Jamaat case. There are many members of Tablighi Jamaat accused of violating visa conditions by attending a religious congregation in Delhi belonging to different countries, have obtained release from court in recent days by means of plea bargaining, by paying just fine. And then the Lok Adalats, as I have discussed. Next slide. And thereafter what it is, what remains, madam? Yes, the difference, what we are achieving. देखो, जहां झगड़ा होता है, I'll say this Rahim Das ji, I remember, रहीमन धागा प्यार का, प्रेम का, मत तोड़ो चटकाए, टूटे से फिर ना जुड़े, जुड़े गांठ पड़ जाए. If you go for litigation, as Mr. Ashish has also said, कि अगर वो जेल चला जाता husband, तो dispute resolve नहीं होता. वही बात है, अगर dispute होगा, अगर केस चलेगा, litigation होगा, तो ऐसे differences arise होंगे जिसके वजह से कभी एक नहीं हो पाएंगे. See here the differences. Looks to past, this adjudication, this litigation, it looks to past and factual aspects of dispute. However, ADR, this looks to future. आगे क्या आने वाला है? आगे ये लोग कैसे साथ में रह सकते हैं या नहीं रह सकते हैं? This is what we see here. एक तरफ हम ये कह सकते हैं कि optimist होता है और एक तरफ pessimist होता है. कि वैसे भी कहा गया है बीती ताही बिसारी दे अब आगे की सुधिले. This is what is actual meaning of ADR. That is to be practiced, and for that purpose, what happens? What is the result of that? What is the end result? See, in adjudication, relationship between the parties not focused. However, here, focus on relationship between the parties. Then it seeks to set up liability or fault. Here, while adjudicating, you will say that you are liable. But here, what you will say? You will say that it seeks the reform of relationship. It results into adjudication results into laying down a general rule. Here, ADR, it results into custom-based solution. And custom is that you have practiced your generations, through your generations. Then important role assigned to advocate, appearing on behalf of, बात तो वही है कि आपके behalf में कोई और बात करता है और आप अपनी बात को खुद present करते हो. Here, ADR, you yourself speak for yourself. That is how the ADR works. Then the next slide, please, madam. Types of cases dealt in Lok Adalat or mediations, that is mutation of land cases, compoundable crime offences, encroachment on forest lands, family disputes, land acquisition disputes, motor accident claims, and cases that are not subjudiced. Then next, madam. The Bombay High Court mediation scheme, all as Dr. Nachiket has pointed out, that many of the high courts, they have enacted their own mediation centers and mediation schemes. Likewise, Bombay High Court has also. Then I'll end this with a share of Mirza Ghalib. बड़ा खूबसूरत उन्होंने कहा था, कुछ इस तरह मैंने जिंदगी को आसान कर लिया, किसी से माफी मांग ली तो किसी से माफ कर लिया. So this is the principle. This is the principle on which this entire mediation scheme is based on. Moreover, this has roots to your Gita as well. See, as Ashish ji has said that, and even Mr. Nachiket has also said that emotion overpowers. Emotion overpowers. Where emotion overpowers, you are not able to decide your question, your dispute. And so therefore it was said in Gita, ध्यायतो विषयान पुंसो संगस्त सुपजायते संगात संजायते कामो कामोत क्रोधोत विजायते. This, when you are yourself so obsessed with your desires, you have this factor of krodh that initiates that वो उत्पन्न होता है आपके अंदर से, and that arises, and because of this क्रोधात् भवति सम्मोहो सम्मोहात् स्मृति भ्रमा स्मृति भ्रंशात् बुद्धिनाशो बुद्धिनाशात् प्रणश्यति। आपको आपका ऐसा सम्मोह उत्पन्न होता है कि आप अपना अच्छा और बुरा नहीं देख पाते हैं, और अच्छा बुरा नहीं देख पाते हैं तो आप अपने प्राणों की हानि कर लेते हैं। Being this the truth, वकील की जिम्मेदारी बन जाती है कि उसने इस सम्मोह से क्लाइंट को बाहर निकालना है, उसे समझाना है कि देखो भाई सत्य क्या है और किस तरीके से आप इसमें आगे बढ़ सकते हैं। With this, I'll take rest, and thank you very much for patiently hearing to me. Thank you very much, Principal Sir. Thank you very much, Amrita Madam, Nachiket Sir, and Akash Ji. Thanks a lot. And as my other panelists have said, that questions are welcome. On the other side, along with the questions, I'll say that this is a time for suggestions as well. And I'm sure that if there are good suggestions, Amrita Madam would be reading it for us. Thank you so much.
Sir. Thank you so much, sir, and thank you for giving us the wonderful historical illustrations that we have for mediation and the provisions of mediation that are prevalent in India. And you have also discussed about the different courts, as well as the Supreme Court is working on mediation seriously, and why you have very clearly emphasized why we need mediation during these times, and it is gaining importance. Thank you so much, sir, for the wonderful lecture. And with this, we are now open to the discussion of the panelists. And I would now like to request our panelists to ask the questions to their fellow panelists if they have any. Nachiket sir, to begin with you, if you want to ask any question or you have any comments about the session.
Yeah. Dr. Mehta, thank you. Thank you, for giving this opportunity once again. And it is wonderful to hear both our co-panelists also, Mr. Akash and Mr. Mahesh, bringing in diverse perspective from their experience as the lawyers. So I just have jotted down here 4 thoughts and 4 issues that I wanted to share with the students once more. One of the things that I have thought is based on my general assessment. I would want to give what you can say a little homework to the students if they would be willing to share that sort of a burden with me. Now, why I want to do that is to help all the law students understand that there's so many things in terms of legal research, even in mediation, that you can do while sitting at home. You don't need to be worried that, when will college reopen in the physical format, you can still do a lot of that work. So one of the small projects is very, very small, just to give you a basic idea that where do we stand. So what you can do, for example, in Kelly Law College, there would definitely be a course going on arbitration mediation ADR course, so in whichever semester. So for example, hypothetically, even if 10 students from 10 different cities who may be in a batch, they come forward to do a small piece of research, what they can do is they can make one common kind of questionnaire for the purpose of seeking responses from the litigants who might have been contesting cases in the district courts. Now, whom do you approach? I'm very sure we will find in our own families and circle at least 5 to 10 people, right? You don't need to move anywhere beyond. So it can be a combination of 5 relatives plus friends or whatever it could be. So for example, 10 students, they reach out to 5 persons, each one of them, with a questionnaire. So you will be able to get 50 responses from 10 different cities. So likewise, they can be different groups of students who can do this exercise right now while sitting at home, and then try to bring the data together, collate it, and try to analyze based on the questionnaires. I mean, अब वो कैसे बनाते हैं वो अलग सवाल है, right? For which I'm sure the law teachers will guide you. That one, कि questionnaire बनता कैसे है, दूसरा किस प्रकार के questions होने चाहिए, because now you're not asking general questions. You're looking at collecting a data which will give you insight कि ये 10 से 15 cities में mediation के बारे में लोगों को जानकारी है क्या, cases हैं तो कितने समय से pending है, below 10 years से, 5 years and so on and so forth. Right? So that's a small sort of a work, and on that basis, trust me, my dear friends, agar 10 to 15 students can also come together and do this exercise, you will be able to come up with a very decent empirical based research paper, rather than looking at कि आप रिसर्च पेपर कैसे बनाएं, बहुत सारा मटेरियल कहाँ से लिखें, आजकल लाइब्रेरी भी ओपन नहीं है, right? So there are a number of ways you can do it. And one of the good things with empirical research paper is you don't have to be worried, जो invariably हो जाता है being a law student, कि कितना plagiarism हो जाएगा, क्या हो जाएगा. आपका data original होगा, आपको उसको interpret करना. I'm very sure, any law school journal will be happy to publish it. One, it may come up original. Second, by virtue of your efforts. One. Second thing I wanted to add here to the law students to tell, adding to what point our friend here Akash has also mentioned, that do read some of the cases which are very important in the mediation. One, you may not find those cases getting a limelight, just say arbitration cases, get a limelight, because the reason is in arbitration there are millions of dollars at stake. In mediation, unless you're talking about the Western mediation, in India, you don't have millions of dollars at stake in the mediation generally, right? So, इसलिए उन cases को इतनी तवज्जो नहीं मिलती, उनकी इतनी चर्चा नहीं होती. But still, to tell you, one of the, at least two of the cases which you should read, arbitration, जैसा मैंने शुरू में कहा था, it has started becoming neo-litigation. In that regard, there is one very good judgment of Delhi High Court, Union of India versus Panacea Biotech. So where there was one judge of the Supreme Court who was a single arbitrator, and as I can correctly recall, and that bench of Delhi High Court set aside the mandate of that arbitrator because for almost 2 years, no hearing happened. But around 76,000 US dollars were already paid as the fees to the judges who were former judges of the Supreme Court, right? And doing the mediation there. So this is, doing the arbitration there. So this is how the arbitration is also under a lot of stress these days. But thanks to some of the, lawyers and judges who are promoting mediation as an alternative in a much viable way. One. Another third and interesting point, when Akash was, mentioning about number of cases out of his experience as a lawyer. So you may want to look at, and even Mr. Mahesh mentioned about some of the cases and aspects with regard to criminal law and all. And you may want to look at one of the cases of 138, dishonor of check bounce, that technically speaking, in a super technical language, it's a criminal offense, right? So, and it's a very interesting thing to see. I'm sure the students of banking law, if they are attending the session here, would already know that it's classically a commercial law, Negotiable Instruments Act, but usme एक amendment insert कर दिया, giving it some flavor of criminal law. So that doesn't make the law as a criminal statute anyhow. But that's been also a debate, that should mediation be explored in 138 cases, which are technically qualifying for a criminal case, but by virtue of they being compoundable. So definitely the answer is yes. In that regard, I would want some of the law students to again to maybe write a small paper on that how the negotiable instruments law, which is basically a commercial law based on the faith of the trading community and the commercial community. So it is only to reaffirm that faith that mediation is generally explored or at least promoted by the courts, as opposed to directly starting your filing line by virtue of starting the 138 petitions. So you may want to look at that. Then last 2 points which I want to just generally mention and make is, which I always start in the beginning of my ADI classes. Some of you might have heard a story. Dr. Amrita, I'll just take 2 minutes. Some of you might have heard the story. If not, I will mention it now and share it with you. That once upon a time, there was an old man in a village who had 3 sons. And so when he was dying, he said that my property is to be distributed in a way that he had 17 camels. So he said that the eldest son will get half of their share, and the second son will have 1/3 of the share, and the third son will have 1/9 of the share. So now these 3 sons wanted to divide 17 camels. I mean, as you can probably see, that 17 you can't divide by 2, 3, or 9. So you can't end up getting any result as such. right? You would be in a deadlock. Now, in order to clear this deadlock, I always tell a lot of my students that this is the kind of lawyers that I would want in the mediation class. And this is the kind of lawyers I would actually want to come out of the mediation class, who can try to resolve this kind of impasse between the clients. And sometimes you need a third perspective to be given by somebody as a mediator for the parties to resolve. So in this case, let's assume there was a one old woman in a village who said there's no point fighting amongst yourselves. You've been, dear brothers, and I have known your father for long, and I am anyhow quite old. I have one camel left with me, and I'm not going to do anything with that camel. Why don't you take my camel and try to resolve your dispute? So they took that camel. So what it led to, 17 plus 1, 18. They tried to once again redo the math, right? So the first son, who had half share to his benefit, so he got 9 camels. The second son, who was expected to get 1/3, got 6 camels. 18 divided by 3. And the last son, the youngest one, 1/9, he got 2 camels. Now you add that up. 9 plus 6 plus 2, 17. So they were still left with 1 camel, right? So the idea to share this small piece of story is that you, as the mediators, are expected to be that kind of generating that kind of insight, that kind of third vision, third kind of a perspective, and making the parties think out of the box rather than fighting amongst themselves, is still, staying together in the harmony. Right, so as you can see, it's a small kind of a piece of story, but those 3 brothers could still, enjoy the property left by their father in the form of the camels, and it was all good. So they could return the camel that they, borrowed from an old lady, right? One. And in the end, I would want to mention that I would rather want to request, Professor Dinkar, that since I mentioned the beginning of my talk, almost an hour ago, sir, that 20th December. 2018, when the Singapore Convention on Mediation was adopted, I would request, if you think feasible, organize one mediation panel or a conference on that day, right? So that can again generate a momentum. And I personally believe we as law teachers can do at least this much. And these days, the good thing is that we don't need to invest any money in conferences and the panel discussions, right? So one of the NLUs, I'm coming up with one program with one of the NLUs very soon. So somebody asked me that, will we have to give any money to one of the judges I'm going to invite? I said, nothing doing. There's no honorarium in terms of, somebody coming as a speaker, and no kharcha, no tickets, nothing doing. But rather, the people would very happily want to contribute. Because at the end of the day, we have to invest 1 hour sitting at our respective places, right? So, sir, I would request, if you want to take this up, so, you can ask your faculty of mediation to arrange a panel discussion on a mediation in a more structured way, in the sense taking up themes which are specific themes, which have a more sort of inclination according to the cases that go on. And you can bring some people who have been doing very hands-on experience sort of work in the mediation, right? So you will be able to commemorate the Singapore Convention adoption. At the same time, students will get to learn. So that's my request.
Good suggestion, sir. A good suggestion. Thank you, sir.
Yeah. Thank you, ma'am.
Thank you so much, sir, for your remarks and suggestions. And of course, we are really inspired by your different thoughts. And of course, our students, they are also very much inspired by you. Thank you so much, sir, for those words. Mr. Akash, your views or any other question?
Ma'am, I would like to make some suggestions for the students as well. That if they want to, understand, and if they want to experience how, these mediation and conciliation works, then one should do their internship in state legal authority. If you go and intern with the state legal authority, what they do is, to the best of my knowledge, they take you to a tour, right? And they organize lok adalats in small villages or small tehsils, I would say. And there they try to redress the problem, and they try to solve the disputes. So what is the criteria, what is the approach that they actually take to resolve such issues? If the student will look into it from the very beginning, it will really help them a lot. And this is something which happens on the ground level. And once you understand that, and if you get more and more interest in arbitration, conciliation, and mediation, then you can go to the family court as well, and thereby you can work under a lawyer. You can intern under a lawyer who specializes in family law, and thereby they'll get a chance to hear that how these mediators talk to the husband, talk to the wives, and how they try to resolve the dispute. So this is a small suggestion, because internships, they play a very vital role in understanding the law on the ground level. So this is something I would like to make this suggestion to all the participants out there, and they can try this. It will help them a lot.
Thank you, Mr. Akash. Mr. Vishwakarma, sir, your remarks or suggestions?
Sure. Thank you all. First of all, thank Gite sir and the other students that they have given me opportunity to say something before you guys. And I must thank two other panelists that they have given such insight of the provisions and such beautiful suggestions for the students. At the same time, I'll take further to the suggestions which my friends have given, by what Mr. Nachiket and Mr. Ashish has given. As Mr. Nachiket has suggested, that yes, the students must have a homework kind of thing. And I assure you, sir, my students, they have already started with it, and they are doing it. They have prepared some questionnaires as regard to plea bargaining and their the mediation part of thing. Even they are posing the question to the judges. They have this way. They are now asking the question to the judges, sir, how many questions have you referred to mediation and what was the ground? Whether more and more cases are to be referred, and how can we do that? My students are really working on that. So thank you very much for appreciating this endeavor of the students. And as Mr. Ashish has suggested, that yes, interning is the best way of getting into the actual battle, of understanding the pressure on the part of the mediators. Yes, that is of course. And as Mr. Ashish has said, only the family courts, but I would go ahead and say that try all the fields, try corporates, try the land disputes, try other disputes. Apart from the family, there are many things. You have to learn it. You have to see it, how you could be of best use to the society. You are the torch bearers of the society. Be the torch. As Dr. Nachiket, he had said that yes, find out in 138 matters whether there is a possibility. I'll suggest, find out the case of Dayavanti versus Yogesh, given by the Delhi High Court, if I'm not wrong. Delhi High Court has...
This is Geeta Mittal's judgment.
Yes, Geeta Mittal's judgment. So there, find out, see how the Lok Adalat plays role, how mediator plays role, and every role has been discussed there, and even a way out of how, if settled, then how you can recover your money. That is beautifully written there. Yes, he has given a beautiful way out to all of us. Thank you so much for enlightening this. This is what I can say. And with this, I'll say that please, you may pose your questions if there are any. I'll try with my friends to answer them. One of them, I think, Mr. Yusuf by Queenie Ahmed. Mr. Yusuf Ahmed has posed a question to me. He says that, could you explain about land acquisition disputes? I'll tell you what are the questions coming in land disputes. The questions are about apportionment. That is the money, the notices given to the people who are notices in that. If they have their disputes as regard to apportionment, then the matter can be referred to civil court through the land acquisition officer. That is one portion there, and there you can decide, discuss, and through the mediators you can resolve it. One. Two, while acquiring the property, the government may not fix your rates properly for that. For enhancement of rates, you go to the courts, file LAR matters. That in those LAR matters, yes, you can request for mediation. Yes, there it can be resolved. Thereafter, you go to the High Court. There also you get the opportunity, as Mr. Nachiketa and Mr. Ashish has given ample of this scope of mediation there. So don't worry, if you have any dispute as regard to land acquisition disputes, you may have the opportunity of approaching the mediators, and through the mediation you can resolve it. Thank you so much, sir.
Thank you so much, sir, for answering that question. Sir, the next question is for Dr. Nachiket, sir. Sir, a student is asking for which disputes is mediation appropriate and what are its advantages?
Okay. So first of all, to tell you, my dear friend, that you must understand that you can actually break it down from the broad ADR perspective, not just mediation. That ADR is best suited for the disputes, one, which are not of the on the criminal side. So mostly all the civil and commercial disputes fall for the purpose of alternative dispute resolution. There is one of the very interesting landmark cases, Salem Bar Association 1 and Salem Bar Association 2 of the Supreme Court, which is given the perspective. And then you have Afcon Cherian case of the Supreme Court, which is clarified in the judgment itself, giving the detailed list that what matters are best suited for the mediation, arbitration, and what matters are not suited for the ADR in its entirety. So when you ask that what kind of matters you can take through for the purpose of mediation, the answer is very simple, that generally most of the civil disputes are eligible for mediation. Anywhere, it's between the private parties, to sum it up, right? Wherever the disputes are against the state, you may probably, the criminal side especially, you may not be able to seek the mediation as a remedy, right? So in the civil or commercial, you can range it from, as we have discussed so far, family matters, rent control matters, property matters, then bank guarantee matters, then negotiable instruments matters. Then you may probably also be able to break down the commercial matters into different ranges. Any kind of contractual breach, any kind of, let's say, even as you can say, partnership deed, as we are having these days, the issue of Luthra partners altogether, coming up there in a big way. So all these kinds of matters can be resolved very easily through mediation. Now the point is that parties may want to prefer the mediation first, or they want to directly jump to the arbitration, right? So that is to be taken care of. So that is a matter which is going to vary from case to case basis. And but then again, in family matters, mediation is something which is done and they are not taken to the arbitration, right? So this is how you are able to see. I would really recommend everyone to definitely go and read Afcon Cherian case and Salem Bar Association 1 and Salem Bar Association 2, which remain till date the landmark judgments in that right, how the Supreme Court has given the complete list. आप लोग जैसे CRPC पढ़ते हैं, तो schedule है CRPC में, जहाँ पे schedule tells you which case is bailable, non-bailable, and compoundable, non-compoundable, so on and so forth. Likewise, this judgment, for example, gives you the entire list. आपको कभी किसी से पूछने की समझने की आवश्यकता ही नहीं पड़ेगी, right? And once you are able to go through the list, you will be able to see it in with the reasoning that why these matters are reserved only for the mediation or arbitration. Is that all right?
I'll add up to this.
Yeah, please do.
I'll add up to this. Mr. Nachiket has rightly pointed out that there's a list. And you may add to this that compoundable offenses, you go there, talk with them, finish it there itself. With the help of the judges, you can finish that. There also mediation works out. In one of my cases, it was rash and negligent driving. We, with the help of the judge, we finished it then and there itself. The complainant and the accused, they sat together, decided, yes, some compensation is to be given, and then it was pleaded guilty, and then it was done that way. So whatever he has given, follow it religiously, I'll say. That would be the right word. Thank you.
Thank you, sir. Thank you so much for your views, sir. Thank you so much for answering the question. The next question is, I think, directed to Mr. Akash. Akash, Ms. Dr. Pradeep Desai is asking you a question that in marital disputes, when tempers are high to get separated, how difficult it is the task of the moderator?
Yeah.
I'm sorry, the mediator. Yes.
Yeah. What I have experienced in a very short span of time, that generally, the marital dispute arises because of impulsive decisions taken by either of the spouse. So if one is very much adamant that yes, he or she has to, proceed before the court, and they want divorce or any kind of, prayer that they make before the court, it becomes very difficult for the, mediators, in the sense that when mediator calls you to talk, they try to find out the problem, that what is the actual problem. But the either of the party, if he or she is very much adamant and they are very much predetermined that they want either a decree of divorce or anything like that, then the mediator role becomes very vital here. And this is how his lawyer thing work here, because these lawyers are only appointed as mediators in high courts as well as in civil courts. There are panel of lawyers who are the mediators, and there they try to find out the actual problem by molding the facts, by chatting to you in a very different manner, by trying to make the surrounding very lively, so that you forget your problem, and thereafter you have certain kind of confidence upon the mediator and the conciliator, and thereby when the surrounding become very much comfortable and the mediator gains the confidence, then he starts the actual proceedings. So this is how the mediator works if the temperament is very much high in such kind of disputes.
Thank you so much, Mr. Akash. And I think there are many questions, but still I think we are way ahead of the time. We had to close this session at 6:30 and it is going to be 7. So I would like to just stop here with the question answer session. And once again, on behalf of KLE Society's KLE College of Law, I extend a sincere gratitude to all the three panelists, Dr. Nachiket Mittal sir, Mr. Mahesh Vishwakarma sir, and Mr. Akash Raj sir, for coming in and having a wonderful discussion and deliberation on this topic of mediation and conciliation. We are really indebted to you for your wonderful remarks, suggestions, your views, and I think all of us will be gaining a lot from this session today. Thank you so much once again, sir. Thank you so much.
Thank you.
Principal sir, any remarks from your side?
No, I will do only that it was a very knowledgeable session and practical insights and an experience. It was a wonderful session. The story was wonderful by Dr. Nachiketa sir, as well as Vishwakarma sir also gave a nice insight with respect to how the mediation started since Mahabharata period and everything. And Akash Raj sir, he gave practical insights of a marital dispute and other things. Let me tell you, it was very much knowledgeable session, and definitely our students have benefited. And as Dr. Nachiketa sir has suggested, we would definitely think positively about that suggestion, and if possible, we'll have another session, sir, on 30th. Yes. Thank you all the panelists on behalf of KLE Society's KLE College of Law.
Thank you so much. Thank you so much, Principal Sir. I would now like to request Professor Pooja to kindly propose the vote of thanks. Pooja, over to you.
Thank you so much, Amrita ma'am. On behalf of KLE Society's KLE College of Law, Navi Mumbai, I would like to express my sincere gratitude and heartfelt thanks to all our panelists for accepting our invitation and gracing this event. This panel discussion has actually educated all of us about different aspects about mediation and conciliation. Thank you so much, sir, for this wonderful session. And I would like to take this privilege to thank our management, Dr. Prabhakar Pore, sir, Chairman of KLE Society, Mr. Mahantesh Kavadimat, sir, Governing Body Chairman, KLE Society, College of Law, MLC, and Chief Whip of Government of Karnataka. Dr. Mallikarjunayya, sir, Principal of KLE Law College, Bangalore, and KLE Law Academy, Bangalore. Our beloved, respected Principal, sir, Professor Dinkar Gitte, sir, for his blessings and continuous guidance. I would also like to thank my colleagues, Dr. Amrita Singh ma'am and Professor Salim sir, for their support and guidance. A big thanks to our student conveners, Tejashri and Apsara, and the whole webinar team for making so much efforts, making this session a grand success. Last but not the least, to our participants for gracing this event and making this event a grand success. Thanks one and all. Thank you. With this, we end the session. Thank you.
Thank you. Thank you once again. Thank you one and all.